So welcome to everybody. Thank you for being with us this morning to that low coffee morning. I'm delighted to welcome Myrtille Lapuelle, partner at Coblence Avocats, and Alexandra Briand, associate at Coblence Avocats. Alexandra and Myrtille will tell us a bit more how to handle my first hiring in France. I will let Myrtille starting, but before, if you have got questions, please put it on the chat, and maybe before about 10:45, I will send you a survey in order that you can fill it in. So, Myrtille, the floor is yours.
Thank you, Catherine. We are very pleased to host this introduction to French employment law webinar. 1 hour to present French employment is a real challenge. So we will focus on the point you should have in mind when hiring an employee in France. We decide to do it through a case study. So I will let Alexandra first present our case study.
Here we go with the case study. So idea, Myrtille, was to work you through a little case study to see what are the key things you should consider when hiring for the first time an employee in France. And we thought it would be more interesting for this little case. So a UK company, Blue Bicycle, would like to develop in France and has decided to recruit its first salesperson. This person is a German national, but lives in Paris and will work from his home in France, even though he might come from time to time to the company's headquarters in London. Blue Bicycle would like to find out more about French employment law to handle correctly this work relationship. So Myrtille will start on with preliminary questions and obligations you will need to consider in this area.
So the first question that Blue Bicycle will have to solve is, do I need to settle a legal entity in France? And the answer is no. There is no obligation to have a legal entity. It is a possibility, but not an obligation. But how the employee will work in France, Blue Bicycle will be subject to the French social security system. We will not discuss here the specific cases of secondment or multiple employers. So Blue Bicycle will only have to register with the National Center for Foreign Firms, which is a simplified procedure. Blue Bicycle will also have to wonder whether it will be considered as a permanent establishment, that is to say, liable or not to pay income taxes in France. We are not tax lawyers, so we will not elaborate on this point, but it should be noted that in December 2020, the French Administrative Supreme Court issued a measured decision expanding the permanent establishment and ruled that a permanent establishment that exists in France, even an agent, is entitled to negotiate the details and make important decisions with respect to the conclusion of contracts on behalf of foreign operator, even if such contracts are formally executed outside of France. So before deciding whether the employee will be recruited or not, you also need to wonder what would be the tax impact. And it could also have an implication on the drafting of the employment contract, because we can adapt the wording to try to make it mitigate this risk. So what type of contract Blue Bicycle could use to hire its first employee? It will have to choose in between different types of relationship. French employment law only applies to salaried employee and not to independent contractors, such as freelance or consultant. The difference between a salaried employee and a contractor is mainly the existence of a link of subordination between the parties. If there is a link of subordination, then the parties are deemed employer and employee. It should be noted that when contracted with an independent contractor, there is a specific duty which is called obligation de vigilance, which in a nutshell is checking whether the independent contractor is properly registered to the French and social administration and tax administration. Blue Bicycle can mainly for employee used an indefinite term contract or a fixed term contract. Generally, companies that we are working with are thinking that fixed term contract will be the more flexible because they are settling their business in France, so they do not know whether they will stay in France. So they think that maybe fixed term contract is the best idea. But in France, fixed term contracts are strictly regulated and only possible for the use of fixed term contract are only possible for limited reason, but Alexandra will explain the case you could use a fixed term contract. So we will recommend a permanent contract. So when you have decided to the type of contract, then it is possible for Blue Bicycle to conduct a background check. We know that it's very usual in the UK. It's less usual in France, and I would say less wide that in the UK. The main point of difference is you cannot really ask for a criminal background. It is only possible for a specific activity or specific position like bank, for example. So here, Blue Bicycle would be limited in the background check, at least for criminal background. In principle, the Blue Bicycle will also have to ensure that the employee will hire it as a proper work permit. Here, in our case, it will not be applicable because the employee is a German citizen. And last but not least, it will have to take care of the pre-hiring declaration, as we explained a little bit earlier. In practice, when a company has only one or few employees, we always recommend to hire a payroll company that would assist with the declaration and payslip obligation. Alexandra will now draw your attention to the main points to take care when drafting an employment contract.
Well, the first thing, when you consider drafting the employment contract, is that you need to consider that the employment contract is only one element, which is part of a more global legal structure. And obviously, when you draft the employment contract, you need to comply with a certain number of rules and regulations. Just for your knowledge, in France, we have a written constitution, which is really at the top of the norms, not really that much relevant as regards to employment law. For instance, you can find in the French constitution that we have a constitutional right to strike in France, but obviously this will not be the more relevant for you on a day-to-day basis. Then obviously we have all the European treaties that we need to comply with and the European norms. Then we have all our laws which are adopted by Parliament, and then we have the government who takes some measures to implement the law through decrees. Then we have the collective bargaining agreement, which are negotiated. And also in each company, we can have some internal rules and regulation, policies, practice. So when you start drafting your employment contract, you first need to consider all this legal structure, obviously, to write correctly your employment contract. Also in France, when you enter into the employment contract should normally be in French. So here, the business is based in London, so you could do the contract bilingual, French and English. But the tricky thing we put in our case is that the guy we were going to recruit is German. So in that particular situation, this individual can even ask you a translation in German of the employment contracts. So it's just that we wanted to make it a little bit tricky in our case. So one really important element when drafting the employment contract is the collective bargaining agreement. It is really rare in France for a business not to be subject to a collective bargaining agreement. So what we would need to do here first is to talk with Blue Bicycle to understand exactly what would be the principal activity in France. We don't really care about the global business, at a group level, but we need to understand what they will do in France. So probably here we would discuss with them, and let's imagine they would answer, well, we will sell bike in France, but at the beginning, we will not have our own shops, okay? So we will sell those bikes to other shops who will then sell them to the end clients. So probably we would consider that they have a wholesale business, which means that the collective bargaining agreement they will need to follow is the wholesale CBA. And it's important to get the CBA correct from the beginning, because as you will see, it has an impact on how to draft the employment contract, such as the minimum level of remuneration, probation period, how to draft the non-compete clause if you want such a clause, and so on. Also, interesting for you, if your business develops in France, which we'll hope, obviously, is that you can also negotiate within your company a company-wide agreement, which would allow you to adjust, for example, certain provision of the industry-wide collective bargaining agreement. You could also negotiate specific rules on working time. So just to know that there are some flexibility in France, and at some point, depending on your needs, you can negotiate particular rules in your company. Now, in drafting the employment contracts, we wanted with Myrti to work you out a few clauses which are perhaps the most tricky or also the most important in drafting when you draft your employment contract. First thing, there's the probation period. So probation period is always optional. Of course, it's always useful when you start an employment relationship to have such a probation period, because it will allow both parties to ensure that the employee is fine with the job, and for you as an employer that this employee is good, obviously, for the job. The probation period is regulated by the law and by the collective bargaining agreement. So you are not free to decide, for example, to tell, okay, I want 6 month probation period, okay. So in our situation, because it's the wholesale CBA, and we assume this employee would be an autonomous employee, so an executive, you could provide for a probation period of 4 months, renewable for 4 months, and you need to put a clause in the employment contract. If you have a probation period, you can quite easily end the contract during that probation period by just informing the employee. You will need to comply with a little short notice period, but it's quite easy to end the contract during the probation period phase. Another clause which is interesting in an employment contract is to add a mobility clause. A mobility clause will allow you to change the employee's workplace without his consent, but within the limited geographic scope that you would have indicated in the employment contract. So it's always interesting, obviously, to have this kind of clause. This being said, you could move the employee somewhere in France, but not, abroad. Or you could not, using this clause, force him to change employer for another company of the group, for example. Also, in the employment contract, an important clause for both parties is obviously remuneration. So usually in old contract, you have a base remuneration. Here again, you need to check the collective bargaining agreement, because the collective bargaining agreement usually provides for a minimum level of remuneration depending on the type of job the employee is on. So you need to check that you comply with that. Also, usually employers want a variable remuneration clause. Here, it would be particularly relevant because, as you remember, the new employee is a salesperson. So obviously, in such situation, you would probably be interested in having a commission system. So it would be important to, in the employment contract, to give the global picture of how you would handle the variable remuneration, even though we usually recommend with Myrti that you don't make everything contractual, because if, for example, you indicate in the contract the targets, you define the targets in the contract. If you want to change the targets, you will need the employee's consent. So it's better to say in the employment contract that here is the basis, the principle of the variable remuneration, but every year I, employer, will define the targets you need to comply. And the targets normally should be also in French, which sometimes is a tricky thing for non-French companies. An important clause also in the employment contract is working time. I will not develop that because we have a specific section of our webinar and Myrti will talk about that. Just here note that depending on the working time organization, you will have mandatory provisions required in the employment contract, such as if you recourse to part-time or if you want the employee to work a number of days per year, then you need really specific provision in your employment contract. Another clause, which is also quite relevant here in our scenario, would be the non-compete clause, because of course, when you hire someone to develop your business in France, such as a salesperson, what you don't want is that person to go to a competitor and to ruin all your business. So here also, when drafting the non-compete clause, you must be really careful because sometimes the collective bargaining agreement limits what you can do. Here in that example, the wholesale CBA doesn't include any provision on the non-compete clause, which means that when drafting your clause, you still, however, need to comply with the case law around non-compete clause. So first, your clause will need to be limited in time. So let's say here it could be 6 months. You need to limit the clause in terms of geographical area. So you need to indicate that this employee is not allowed to compete, for example, in France. And also you need to provide for a financial compensation, meaning that at the end of the employment contract, when the employee will have to comply with the clause, you will need to pay him a certain amount of money during the 6-month period of the non-compete clause. Usually, based on case law, we would say that paying him an average of 30% of his average remuneration would be sufficient consideration to have a valid non-compete clause. Also, an important thing to put in the employment contract is a waiver provision, meaning that at the end of the employment contract, if you added a waiver clause, you can, as employer, tell the employee, well, in the end, I decide not to use the non-compete clause, so I release you from your obligation. And of course, then you will not have to pay every month the financial compensation. But it's really important to have it in the employment contract, because if you don't have this clause, then you will have to pay the indemnity and you can't waive the clause. Another point, which is a little bit more technical in terms of drafting, is if you decide to recourse to a fixed-term contract, because fixed-term contracts are regulated under French law. The first thing to note is that fixed-term contract can only be used for precise and temporary tasks, and also for limited grounds defined by the law. So, for example, you can use a fixed-term contract to replace an absent employee. Or you can use a fixed-term contract for a temporary increase of the activity. But you can't use a fixed-term contract for a permanent business. So here, if we take again our example of our blue bicycle company, the key aspect of the business is to sell bike. So probably we would tell you don't use a fixed-term contract because this is the central element of your business in France. If you don't have a salesperson, you don't have a business in France, okay? So it's a permanent activity. So probably we would be a bit cautious, before telling you, yes, do a fixed-term contract. Also, the fixed-term contract must be a written contract. You need to handle this contract in the 2 days after starting the employment to the employee. The duration of the contract is limited, usually cannot be more than 18 months. Although in really specific situation, it's possible to have an open term fixed-term contract. So for example, you recruit someone to replace an absent employee, then you can write that this contract is until that employee returns to work, for example, from her maternity leave. Also, if you want a successive fixed-term contract, sometimes you might need to comply with a waiting period between fixed-term contracts. Also, the rules on termination of this fixed-term contract are really specific. So, for example, a fixed-term employee cannot decide to resign. He could decide to end his contract because he proves being hired by another company under a permanent contract. On your end, you can't decide the morning, well, sorry, it appears I don't need you anymore. And you can't just tell the guy, well, we will end the fixed-term contract. What you can do is end the contract only if you prove a gross misconduct of this employee, for example. So you see, fixed term contract can offer some flexibility, but also you are limited on your ability to terminate the contract. And at the end of the fixed term contract, you will have to pay an indemnity to the employee, which represents 10% of the remuneration this employee will have received. Although there are a few exceptions where you will not pay this indemnity. So for example, if you terminate the employee for gross misconduct, or if you offer the employee a permanent job and he refuses a permanent job, then you don't have to pay this indemnity at the end of the fixed term contract. So now I will leave Myrti work you out on working time a little bit.
So working time is probably one of the more famous French employment parts, and also one of the more expensive. So French employment law is very wide, but if you need to focus on one specific point, it's really working time. So basically, as you may know, the usual working time hours is 35 hours a week. This doesn't mean that it is always the applicable working time. It's not an absolute limit. It's only mean that you will have to pay overtime either in time or rest for any hours that the employee will work beyond 35 hours per week. There is also an annual overtime selling that is usually 220 hours. The CBA can provide for specific selling. Regarding the wall sales, the selling will depend on the type of activity, but for Blue Bicycle, the overtime limit would be 220 hours. There is also two other type of working time that you could consider when hiring your employee. There is an exempt status like in the US or in the UK, which is that you will not count any hours. But this specific working time organization is only available for manager of the company that are very autonomous, that would be in a position to take decision and with a very high remuneration. And the trend of the case law is to limit the position that you can offer this exemption of working time. In between, you have a very specific working time organization, which is what we call in France forfait jour, which is working time in days, which is you will not count hours, you will count days. This option is generally available for autonomous employee. You will need this option to be provided in the CBA. It is also possible to sign an agreement at the level of the company, and we will not enter into this level of details, but it is now easy to sign this type of agreement, even in a small company, because you can do it with the employee when you do not have any employee representative or unions. So for the working time in the organization, you will not have any overtime, but so you will have a certain number of days, and in the wholesale CBA, it would be 216 days. So the employee will work for this maximum day, but you will have to implement specific measures to ensure that there are a balance between work and personal life. So you will need to implement interviews, you will need to implement disconnection right. So that is the drawback, to be sure that the employee at the end of the day will not claim that in fact is not working in hours and ask for overtime for the last 3 years, which could be very, very expensive. And you should know that obviously this type of litigation is not during the contract, but more after the end of the contract, when they also claim that the termination is unfair. I will go quite quickly on the maximum working time, day and week, because they are provided by law, and you can find that very easily on our slide. So I would more let Alexandra focus on much more tricky obligation.
We wanted to talk a little bit about working from home, because as in our example, our German citizen would be working from his home in Paris, because at least from the beginning, Blue Bicycle will not have an office in Paris. Of course, with COVID, remote work has become a hot topic worldwide. And so it's why we thought it would be interesting to talk a little bit about that. So first of all, remote work is on a voluntary basis, except of course in exceptional circumstances, such as the COVID situation, where for health reasons, you could force an employee to work from his home. What we recommend when using remote work is to formalize the recourse to telework, either through the employment contract or through a company-wide agreement or through a policy. It's really important to define the rules under which people are working from home to then avoid litigation. In particular, recently, we've seen quite a lot of litigation when the employer wants to end remote work, but the employee is saying, no, I've been working remotely for years. You never told me that you could at some point end it. So the employee refused, and usually it ends with a litigation. So it's why it's really important to formalize, the recourse to remote work. So here, in our scenario, with this first employee in France, probably we would recommend to have a specific clause in the employment contract to define the terms and conditions under which this employee will work from his home. First of all, Blue Bicycle will need to provide this employee with the necessary working tools, such as, of course, computer, a mobile phone, printer, and so on. Also, because Blue Bicycle doesn't have an office in Paris, in practice, this employee will be forced to work from his home. So here, you would have to pay that employee a specific indemnity to compensate for the fact he's using his home for professional reasons. The amount of this indemnity is not defined by law. However, regarding case law, we would say that 100 euros per month would be sufficient. In addition, you will also need to pay for the employee's professional expenses. So I don't know, for example, he needs to buy paper, pens, of course, then he can ask you to reimburse you. He can ask reimbursement for those professional expenses. Also, one recent question that we have to handle with Myrtille is now employees tend to decide to relocate their home, sometimes outside France, outside European Union. Sometimes we have some employees who just decide to go and live in Asia. And this can trigger some difficulties regarding social security contributions, because normally, if the work is in France, then you pay social contribution in France. However, if this employee doesn't work anymore in France, then you might need to pay social contributions under another law, which is not necessarily what you obviously as an employer you wanted to do from the beginning. So what would be recommended in the employment contract is to really indicate that, of course, this employee is allowed to work from home, but from France, okay? Because you don't want at some point having to pay social contribution, I don't know, somewhere in Asia, just because he decided to go and live there. Now that we have talked about how we draft, the employment contracts, we thought we might go a little bit further than just talking about hiring, an employee in France, because when a business starts in France, obviously you're also interested to know how can I terminate, that employee, because perhaps, unfortunately, your business will not be successful, or perhaps this employee will not fit for the job. So we, of course, here, because our webinar is quite limited in time, we can't detail every rules, but we just want to give you a little overview of the main form of termination of the employment contract. The first form of termination of the employment contract is resignation. So resignation is when the employee himself obviously decides to end the employment contract. In terms of format, it's quite easy. I mean, basically, he will just inform you. We recommend, of course, a written information for question of evidence. And the employee will have to comply with a notice period. In our example, with the wholesale CBA and this employee being an executive, the notice period will be 3 months. The employee can work during that notice period, or you could decide to tell him not to work. But if so, you would still have to pay the employee. And also, in France, it's important to note that we don't have the concept of garden leave, meaning that if you tell this employee, stay home, don't work, first you need to pay that employee, but this employee is also free to go and work for a new employer. Okay. So it's important to know that we don't have the similar concept as garden leave. Another form of termination is dismissal. So dismissal obviously is at the initiative of the employer. The rules are not exactly the same if we consider dismissal on a personal ground, for example, poor performance or misconduct, or if dismissal is for an economic reason, the so-called, of course, redundancy. So you need to consider what is your termination ground, and then determine, what will be the correct procedure to follow. One common element to whatever form of dismissal is that you need what we call a real and serious ground to dismiss the employee, meaning that in case of litigation, you need to prove the reality of the ground you use to terminate the employee. So for example, it's not just sufficient to say, I dismiss you for poor performance. In case of litigation, you will need to prove the actual poor performance. And sometimes with Myrtille, we have some difficulties because sometimes managers do the appraisal of the employee and didn't really tell the truth in the appraisal and perhaps pay the bonus to the employee. And then they come in, the client comes and see us and tell, oh, I want to dismiss this employee for poor performance. And then of course, it's difficult for us to prove the reality of the poor performance. So just to tell you that it's really important for you to keep track and keep the evidence of the wrongdoing of the employee or the poor performance of the employee if you want to dismiss the employee. If you dismiss the employee and he's not satisfied with this decision, he could initiate a litigation. In France now, since 2017, we have a legal scale regarding the amount of damages an employee could obtain before the employment tribunal. So this scale gives you a number of months maximum you could be sentenced to, depending on the employee's length of service. So for example, for an employee who has only 2 years of length of service maximum, you could have to pay 3.5 months of salary. So depending on the length of service, you have a lower or higher risk, of course, in case an employment tribunal consider that the dismissal is unfair, meaning that you are not able to prove this real and serious cause of dismissal we were just talking about. Another form of termination is what we call amicable termination of the employment contract. Both parties need to agree on amicable termination, and they need to sign a specific amicable termination form. Once this form is signed, both parties have 2 weeks to change their mind. If nobody changed their mind, then you send the form to the administration, the labor administration, who has again 2 weeks to approve the amicable termination form. When you agree on amicable termination form, there is no notice period. You only need to agree with the employee on a termination date, which must at least be the day following the approval of the administration. So in practice, we recommend at least 5 to 6 weeks between the signature of the amicable termination form and the termination date. You also need to agree on a termination indemnity, and the minimum amount is equal to the severance indemnity. The severance indemnity is an indemnity you must pay to an employee when you dismiss that employee, except in case of gross misconduct. And the amount of this indemnity is determined by the law and by the collective bargaining agreement. And the longer the employee has stayed in the company, the higher will be the amount of the severance indemnity, because the formula takes into account the length of service of the employee. Another termination option, which is rare, is what we call constructive dismissal. Basically, usually it takes the form of an employee who sends you a letter saying, he doesn't say he resigned, he says, I leave my employment because I consider that you, as employer, you have done some wrongdoing, some mistake. I don't know, you didn't pay my bonus, whereas I consider I should be entitled to a bonus. So the employee ends the employment contract and usually then goes to the employment tribunal to have this termination reclassified as unfair dismissal and to obtain the indemnities he would have obtained in case of dismissal, which is the notice period, the severance, and also damages for unfair dismissal based on the legal scale I just mentioned a few minutes ago. We hope with Myrti that your business, of course, in France will develop. And we just wanted to give you a really quick overview of what is staff representation in France, just to reassure you about that topic. In France, you need to elect what we call a social and economic committee only when you will have 11 employees or more over 12 consecutive months. So here, in the situation of Blue Bicycle, it's not immediately, obviously, that they will have to elect a social economic committee, because for now, they only have one employee. But at some point, if they reach this threshold of 11 employees over 12 consecutive months, they will have to elect a social and economic committee. This committee will then have to be re-elected every 4 years. And the fact that the business initially comes from London is not an exemption, okay? So you will need to have to elect a social and economic committee if your French number of employees reach the threshold we just mentioned. The role of the social and economic committee also depends on the number of employees you have in France. If your number of employees is between 11 and less than 50 employees, the role of the social and economic committee is quite limited. Basically, the employee representative will only be there to raise complaints, raise individual and collective claims. So for example, the member of the social and economic committee can come to you and ask you a question on why you didn't pay your salary on the correct date this month. Also, they are here to promote health, safety, and working conditions. So for example, an employee could tell a member of a social and economic committee, oh, I've been bullied, at the workplace. And then the social and economic committee could raise this concern to you, and then you would need to investigate with the social and economic committee. Also, they could bring some questions to the labor inspectorate. And in very limited situation, you would need to consult the social and economic committee on certain topics, such as collective redundancy, or if you want to dismiss an employee who has been declared unfit to work by the occupational doctor, then you will need to go before the social and economic committee. And basically, below 50 employees, you only need to do one meeting per month with your social and economic committee. When the company will grow bigger and the number of employees reaches 50 employees or more, then you need to more regularly consult your social and economic committee, notably on 3 mandatory topics every year, which are listed here on the slide, which is financial and economic situation of the company, the strategy of the company, and the social policy of the company. However, the law is quite tolerant, meaning that if at some point you reach this threshold of 50 employees, you have 1 year to comply with all your obligations. So during 1 year, nobody will say nothing to you if basically you don't do the 3 mandatory annual consultation. Also, the role of the social and economic committee is a bit more extended, because you will need to consult them on any major, for example, reorganization project And in some specific situation, they can also be assisted by an expert, such as an accountant. So if you present them with a reorganization project and you tell them that there are some economic difficulties, then they could use an accountant to help them understand the economic figures you would bring to them to justify it about the reorganization project and, in our example, potential redundancies. So I leave it to Myrti to have our closure word.
So we are we have some minutes left before the end. So I don't know if you have any question on what was just explained. So we can have that maybe hiring an employee in France is not the nightmare that often people think it is. And that it's not worse than, for example, in Germany or in Spain. There is no co-determination right in France, and also contribution might be high, but we have now also some flexibility on termination, working time, and other type of thing. One point that maybe we can draw your attention to is, we didn't discuss that. We know that in the UK, there is a lot of practice of loan of employee through umbrella company or different type of company. Maybe you need to know that loaning employee in France for benefits, it's strictly regulated. So only umbrella company or temps company can loan employee for benefits. So in either type of hiring must be very carefully looked into. I don't know, Alexandra, if you want to add anything else, or Catherine, maybe.
Yeah, perhaps Catherine, about the survey. No, I saw that you launched the survey. Exactly, I launched a survey during Myrti conclusion. I hope there is some questions, but if there is no questions, it means that it has been clear for everybody. And I hope it will help everybody. Anyway, this session this morning will be on replay on our website, on our channel YouTube, and sent on social media too. So you will have the opportunity to look at it again or to listen to it again. No questions? Everything clear? Did you learn things? And I think, Catherine, we have another webinar at some point in April. Yes, that's right. The 30th of April on labor law, litigation in France, and it will be at the same time, 10 p.m. in order to get British companies to join us.
I will also mention that we have an employment newsletter in English, so that will issue each month. That would generally summarize the modification in law and case law. So if you are interested, do not hesitate to ask Catherine or us to be on the list.
Yes, and if you want, so I can see that some of the participants are leaving and say that it was very clear, and thank you. So if there is no questions, there is a question from Mr. Chan. If the employment contract is in 2 languages, does the French version always prevail, or could we provision otherwise? Well, normally it should be the French version that should prevail. However, in our example, it was a little tricky part because you remember that the employee was a German national. So if he asked for a translation of the contract in German and there's a difference, then it could be the German version who prevail because he's not a French national. But if we make it simple, yes, normally it should be the French version that prevails, which is why it's always good if you do a bilingual contract to ensure that the French translation is correct, because sometimes it's not a joke, but we've seen employers that just do a Google Translate of the English contract in French, and then it's really a nightmare because they really have major problems because the translation is horrible in French. And then we have a problem, I don't know, calculating the variable remuneration because the French translation is not at all what you intend to do in the English version. So it's kind of a joke, but it happens.
Yeah, the litigation that we have around language is often about variable remuneration and targets. And, you know, if you have a French employee, there is an obligation to have also the terms and conditions of the variable remuneration in France. Otherwise, the employee could obtain the maximum amount that is possible. So this is also an expensive matters.
So I think people are leaving and everybody think it is clear, and thanks you. So I will also thank you very much. And I will be delighted to welcome you again on the 14th of April on that new event. I wish all of you a nice day, and I hope you will have a nice weekend, and see you very soon again on a session of the chamber. Bye.
Thank you, Catherine. Bye-bye.
Bye.
Thank you, bye.